Hey, remember when I said this?
The law requires that Brenay receive a notice of exemptions. I'm not sure what the formal term for it is, but essentially it's a time period where she can declare any assets that she owns that she believes should be exempted from collection efforts, such as a car of high value because she needs to be able to get around, or a work laptop. Assets that are of high value that she can prove, hey, this will affect my ability to live and function as a human if you take them away. Do bear in mind that North Carolina does have some strong exemption laws. They are there to protect the person being pursued from getting all of their things stripped. You can't leave somebody without basic living essentials as much as you'd like to. If Brenay files those motions in time, the court can decide what assets are exempt. If she doesn't do that, Akira can proceed to the next step, which is the one most commonly heard of. Step 4. Once the exemption period ends, Akira can apply for what's called a writ of execution.
That is exactly where we are today. There is a new document uploaded to the court record. It is called a Notice of Right to Have Exemptions Designated. Let's take a peek at this doc together. Per usual, I am a certified law nerd, bona fide non-attorney. This is not legal advice. Let us begin. In plain English, this is a required step under NC law once a money judgment is being enforced. It requires that a judgment debtor be given a formal exemption period before any property can actually be taken to satisfy a judgment. This filing is what starts that process. The notice tells the judgment debtor in writing that they have 20 days to respond. During the 20-day window, the debtor has a few options. They can list property they believe is legally exempt from collection, they can request a hearing before the clerk to argue exemptions, or they can do nothing, which means they waive certain statutory protections. This is not a punishment document, it's a due process document. I'm speculating here, but I think this may explain why we saw the earlier writ of execution did not move forward. If the exemption process hasn't formally triggered yet, execution typically pauses until that's complete. That's not unusual, it's just procedural. Now that the notice has been filed, once it's properly served, the 20-day clock starts. If there are no exemptions resolved or waived, and if there is no stay of execution put in place due to a supersedious bond that has been posted pending appeal, there is nothing stopping us from moving forward. When I say us, I mean them. I don't know why I just said us, as if I'm issuing writs over here. In short, barring any other pauses in collection, we can expect to see another writ of execution filed once this exemption period ends. And that's the law doing law things. In order, on a timeline. I will keep you posted.